Sue Kedgling.
Speaker, I noticed there was a headline in today's Herald, New Zealand Herald, and it says, allowing the mining industry to self-regulate was an unfathomable mistake. And I think exactly the same thing could be said for the leaky home fiasco, because allowing the building industry to effectively self-regulate has turned out to be an unfathomable mistake, and one that has created, as many have pointed out, the biggest man-made disaster in our history. Now, the Minister said in his speech that there wasn't any one cause of this fiasco, but actually there is one underlying fundamental cause, and that is the passage in 1991 of the Building Act, which was passed unanimously by both Labour and National parties in this House, which deregulated the building industry. That legislation wiped out most of the previous protections around building new homes and dwellings. It allowed builders to enter and exit the building industry without any real liability, any accountability or costs. It removed requirements around skill levels and training. It loosened council inspection procedures. It allowed private sector building certifiers to compete with local council inspectors for work and issuing building consents. And of course it deregulated standards, and that of course allowed I think it was Standards New Zealand to allow the use of untreated timber and monolithic cladding. So under the new era of deregulation ushered in this Parliament by both the National and Labour parties, who were wildly enthusiastic about deregulation and what it would do for the building industry, under it anyone could effectively develop or build a home. They could build a house, then wander off to the Gold Coast in Australia, as so many did. What we got was a whole lot of cowboy developers who didn't give a damn about anything except trying to cut costs and build as cheaply as possible and get as much profit as they possibly could with no responsibility. And of course we got a whole lot of builders who weren't trained as builders, and so it is a saga of greed as well as of deregulation. So basically, as I said, everyone in the House at the time, in the 1991, argued they were swept up by what was the ideology of deregulation at the time. The arguments, I look back at some of the arguments in this House at the time, this new Act, it was going to reduce building costs. It was going to increase competition in the building sector. It was going to save money. It was going to boost the building industry. Instead of these wonderful promises that both sides of the House assured us were going to happen, instead of which it has actually undermined confidence in the entire building sector. It has resulted in families all over New Zealand living in mouldy, damp, unhealthy, rotten homes, and the Minister himself acknowledged that the dreadful mould that many are exposed to, Stachybotrys, can actually kill people and probably is killing people even as we speak. It has resulted in endless misery, a $22 billion bill for taxpayers, all of this because this Parliament decided to deregulate the building industry and leave it to the marketplace. So let us be quite clear. If there is an underlying reason for this, it is because this Parliament created the problem by passing flawed legislation that deregulated the entire industry, and it is therefore, by that standard, it is Parliament's responsibility to resolve it. I mean, we should be held accountable, not the innocent homeowners who are stuck in cold, rotting, damp, insanitary homes. They didn't create the problem, although their lives have been blighted, in many cases ruined, because they made a fateful decision to buy, in good faith, a home that is now leaking like a sieve. They are the innocent parties in this, and we should remember this. This problem was created by this Parliament.
Can I just remind the member that, as I mentioned to the previous speaker, third reading speeches are about the contents of the bill as reported back from the committee. This is, your speech is about a first reading speech. Now, while it is fine to bring up the points that have led to where we're at, 5 minutes on nothing that's related to what's in the report back from the committee is not permissible, and there's a number of standing orders on this. So with the remaining time, I'll ask the member now to concentrate on the purposes and the contents of the bill.
Mr Speaker, I believe, and I've said before...
Look, there's plenty of speakers' rulings. Order.
But I wasn't even challenging your rule.
No, I'm just mentioning to the member, if we looked at 117, 2 and 3, if you want to have a look at them, it's very clear. So I'm just asking the member on the time remaining that we actually now concentrate on what's in the bill. This is a third reading speech. Sue Keighley.
If we do not learn from history, we will recreate it. And that is why it is so important to do what the Minister did. The Minister spent a significant amount of his speech arguing, giving his version of what he believed created the problem, and he was not called to order by the Speaker. It is also the reason why many submitters...
That's a direct challenge to my ruling. I've been very fair in allowing all speakers an opportunity to come back and go back to how we came to be in this position. And I've given a fair leeway in that respect, and what I'm saying to the member now, as I did to the previous speaker, in the time remaining, just concentrate on the contents of the bill. Sue Keighley.
And this is what I was saying is the reason why many submitters argued that if Parliament had created the problem, then surely Parliament must be accountable and liable for the problem they created. And so while we acknowledge that the Minister and the efforts that he's made to solve this intractable problem, that we are nevertheless concerned that the legislation, while this legislation will protect the Crown, which created the problem, from liability, and limit the Council's liability, it will not protect or benefit many innocent homeowners who are excluded from the provisions of this bill because they fall outside the 10-year timeline, nor will it protect many, many people in multi-unit dwellings. In our view, it is unfair and unjust that people who are outside an arbitrary 10-year time frame, through no fault of their own, will miss out on the financial package or the provisions of this bill if their house was built in the 90s. Miss out completely. And by some estimates, as many as 15,000 to 20,000 homes were built before the 10-year time frame and will fall outside the time limits in this bill. We believe that is unfair and arbitrary. We continue to argue that the provision should be open to homeowners whose homes particularly were built in the 90s. And we supported strongly amendments to the bill which would have allowed the provisions of this bill to apply to apartment and multi-dwelling owners who are effectively excluded from the package because of the difficulty of getting 75% of owners in a body corporate to agree to a package and the difficulty of getting banks to lend to body corporates. Around 90% of apartment and multi-unit legal claims are stalled because owners can't afford to pay legal and other fees. And experts point out that actually it is the apartments, the multi-unit dwellings, that are most at risk of weathertight problems, most likely to be suffering from these problems, and they make up 25% of dwellings affected by weathertight problems. So we've got an estimated 15,000, 15 to 20,000 missing out because of the time frame, and we've got all of these others, up to 25% of people of dwellings affected by weathertight problems also missing out on this package. And we predict that if we don't deal with those people, we may be back in this House some years on dealing with this unresolved problem. While we think this is a positive step forward, we need to remember that, as others have said, the experts are predicting that up to 80 or even 100% of houses built with monolithic cladding and untreated timber will fail, irrespective of their design, that many argue that, contrary to official assurances, there are still houses that were built after the reforms of the building code that leak like a sieve, and despite the fact that their builders are using treated timber. There are still builders out there who are not registered builders, developers who don't give a damn, owners who are trying to cut costs and build as cheaply as they can. And we still have the huge health problems of stachybotrys, of people living in damp, leaky homes with these tiny spores which, when inhaled, cause huge breathing problems, asthma, other serious respiratory problems. From a health perspective alone, we should be doing everything we can to fix the homes, because otherwise we'll be paying for the situation through our health bill. So we think as far as it goes, it is a good package. We have said give credit where it's due. We've congratulated the Minister for what he has done, but we think that it is a mistake to leave out all of those people who, through innocent parties, bought homes in good faith in the 90s, people in multi-dwelling units and apartments, and of course also people who simply cannot afford the 50% loan.